Well, I'm delighted you all are here. My name is Michael Roosevelt. I'm with the Judicial Council of California. I'm a senior court services analyst. This is a very, very important topic that we think really brings closer to the experience of people who interact with our court who are impacted by mental health, behavioral health issues. We see this as an interactive dialogue that's going to engage you in a conversation around an important topic. It will be useful and practical to the work that you do in the courts, regardless of if you have a collaborative court, a mental health court, drug court. We think this content will be extremely useful to you as you do the work that you do for the courts and the justice system. So we call this one Mental Health Lived Experiences. And we are really delighted to have two people who I think some of you may know, Judge Lawrence Brown, Superior Court of Sacramento, and Trina Hatler, Program Coordinator for TCore, who are joining us today. So let me highlight sort of what we hope to accomplish during today's session. We want to learn about, and we really want to hear about the experience of those who come in contact with our courts with behavioral health issues. So you have an opportunity to hear excerpts from recorded conversations with folks who are sharing their experiences. We are really wanting to invest in public trust and confidence. And so we think our understanding of the topic of behavioral health issues and how we interact with people who are impacted by it can really improve public trust and confidence in our justice system. Then we want to identify and really look at behaviors that might be an indicator of a person who in our court system who's being directly impacted by behavioral health concerns or issues, and maybe in a crisis. Then we want to discuss some effective strategies and approaches that we can do to address the needs of folks with behavioral health issues. And so those are sort of the four core areas that we are going to really spend time today. And really, you are the experts, and we want to hear a lot from you. So I'm going to pass the baton on to Judge Brown. Judge Brown.
All right, well, good afternoon. And what I want to do first is to thank Trina Hatler, who is a program coordinator over at TCore, which is here in Sacramento County, providing mental health services. I have both learned at the feet and worshiped at the feet of Ms. Hatler since I took over our mental health court back in 2013. And when Michael said, hey, you should get someone to join you who knows what they're talking about, I knew exactly who I was going to turn to. Trina, do you mind telling us a bit about your background and what it is you do on a daily basis?
No problem. Thank you, Judge. My name is Trina Hatler. I'm the program coordinator at TCore, which is a program within Hope Cooperative here in Sacramento County. TCore is a moderately intensive outpatient program here in Sacramento County. We serve 700 individuals with severe and persistent mental health challenges. The majority of the folks that come our way have had difficulty connecting to treatment of less intensity and need a little more support. So our program consists of case managers, of psychiatrists, nurse practitioners, nurses. We have benefits and enrollment specialists. We have intake clinicians and therapists, clinical director, all kinds of folks, all designed to support our population in the community and just to be successful in managing their mental health symptoms and living in the community. TCore has been connected to the mental health court just over 10 years back again. And TCore has, of our 700 folks in the program, we have just over 70 enrolled in mental health court, and then a whole bunch others in mental health diversion. So navigating the courts asking folks to do things in their treatment and us navigating treatment is definitely something we do a lot. So I'm the program coordinator here. I oversee a bunch of specialty staff and also am the liaison for our mental health court.
And Trina's probably the busiest person I know. And so having imposed on her both today and over the many planning sessions we've had, I am forever grateful. So my name is Larry Brown. I'm the supervising judge for our collaborative courts here in Sacramento County, which does include 3 mental health treatment courts. had sort of inherited the mental health court in 2013 as I rotated to our master calendar court. So it's sort of by serendipity that I had the assignment. That court had been in that courtroom, and there'd be a judge who would just rotate through every year. And what I found was that I truly enjoyed the work that the court brought. And those of you who are joining us today, who are involved in behavioral health courts or mental health courts, I think you know what I'm talking about. Now, I will also note that I have a sister who is schizophrenic. This has been a good 40 years or so now, and she's quite seriously mentally ill. And I always like to say, I would love to tell the story that somehow I sought out the mental health treatment court because of my sister. But in point of fact, I had some reluctance, in part because I think any of us who have experienced someone in our lives who have been struck by a serious mental illness, I think there's some trauma that certainly comes with that, a sense of loss as to this person who had been in your life, in my situation as my older sister, and then changing seemingly overnight. I also had a good healthy dose of Catholic guilt that I had not been involved enough in her life over the years, sort of leaving it to my parents, and particularly my mom, to really deal with my sister Eileen. I will note that with my mother's passing just last week, that now I will be stepping up into the role of special needs trustee for my sister, who called me at about 11:30 today to let me know she had just gotten her monthly injection. So there's lots of forces going on in my mind. But I have kept the mental health court since 2013. I got my presiding judge permission to adopt the court. So when I was back in jury trials, my trials would not be in session. I now am exclusively collaborative courts. These 3 courts that we have are broken up by levels of care. And so our Tuesday afternoon every week is the TCore calendar, the intermediate level of care. And we have about 170 or so people in these 3 courts at any time, which is up considerably from the 25 to 30 we had when I took over in 2013. Now, we could go, this was Michael's slide here, but I think Octavia, we could, we're past this at this point, I believe. And if we could go to who is this for? Who is the webinar for? And just populate the screen if you would. But essentially, the real answer is it's for all of you who signed up. Otherwise, you wouldn't be here. And we're hoping to make this a good use of your lunch hour that you have taken for this, I think, important topic that all of us are address in our courts. I'll note we designed this really not to be exclusively for those of us in the collaborative courts, but our hope is that this will lay some foundation for being able to educate judges, court staff, attorneys, and others who are outside of the collaborative courts, because goodness knows we have persons suffering from serious mental illness who appear in all of our courts, like Michael had noted, whether that is our just felony or misdemeanor calendar courts, to juvenile delinquency, dependency, probate, family, you name it. This population absolutely is an important client of the superior courts that we have across the state of California. And so our hope is just to share some insights. We can go to that next slide there, Octavia. Thank you. We first wanted to put you all on the spot by making you all do some test taking here with a basic poll of getting some idea, what do you estimate the prevalence of serious mental illness to be in the United States? You've got 4 options. Remind us, Jenny, what can they do to vote?
So what we're going to have them do, this is Michael, we're going to have them, rather than do the poll, put it in the chat. So I want you to sort of put in the chat whether you think it's 1%, 4%, 10%, or 25%. So don't think about it too much, just put it in the chat. I'm seeing a lot of C, 10%, 25%, 25%, 10%. Keep it going. This is really good. Wow. It seems like they're hovering around 10% and 25% as they come in. We'll give it another 30 seconds or so to kind of get a sense of what more people are thinking about. I'm going to give you a chance to respond. We have a lot of people on this webinar, so I want to make sure you get a chance to respond. Okay, thank you.
So Michael, looking at the chat, what do you sense to have been the leading answer?
The leading answer hovers around, I would say, about 10%.
All right.
Approximately 10%, although 25 and 10% tend to kind of match up a little bit. It's like a race, but those two are the numbers that we've seen predominantly.
All right. So Octavia, if you would advance us a couple, there you go. And so now we have the answer. It's 4% of persons have a serious mental illness in the United States. And I think that our collective responses in chat will help frame some of our discussion going forward. But before we do that, Trina, would you give some examples of what's considered a serious mental illness?
Yeah, no problem. So a serious mental illness can be any mental, behavioral, or emotional disorder that results in a functional impairment in your life. So where you're struggling with symptoms that are impairing your ability to function in the community, at your job, at home, at school. So it's not specific to any one diagnosis. Here at TCore, the majority of the folks we see have a psychotic disorder, so schizoaffective disorder, schizophrenia, or any of the psychotic disorders. And those are considered serious mental illness because they severely impact one's ability to function across different facets of the community.
Thank you. And if I recall correctly, it used to be that in the DSM that they would talk about an Axis 1 diagnosis versus other axes. And I think the current DSM-5 has gotten rid of those denominations, and instead much more along the lines of the definition that Trina provided us. Let's go to the next slide. Now, folks, here we have a new polling question, which I assume we're going to be doing in the chat room again. What do you estimate the prevalence of serious mental illness to be in our criminal justice system? So folks who are in jail and or prison, what do you estimate the prevalence to be?
They are coming in, and I'm seeing 24%, quite a few, 24%, hovering there. 17%. Keep them coming in. Pretty impressive group, hovering around 17 and 24% range. All right. Thank you so much for participating in the poll. Let's have our reveal. We'll go to the slide that gives the pie chart.
Hold on, before you do the reveal, Michael,
okay.
Where were the kind of the lead results in the chat?
It looks, again, it was really split. But I would say the largest percentage by just a nudge would be about 24% D.
Great. All right, let's go ahead for the reveal now. All right. So we are at, is it 17%? And so folks, pretty much you all got it right, because other surveys, other polls, depending on what jurisdiction or the snapshot in time, certainly seen statistics that get us closer to that even higher number of 24%. And so I think, and I want to pause on this slide right here, because we wouldn't want this to be sort of to misinform the general public. Not all of us who are here on this call who hopefully have some understanding of all these things, but this could look rather almost stigmatic to say, oh, well, look at that. People who are seriously mentally ill, they're more inclined to be criminals. Look at that, they end up in the county jail at a disproportionate rate to their percentage of the population. But I think for many of us, the numbers aren't all that surprising, not for that reason, but because when we think about the challenges that many persons suffering from serious mental illness have in our communities, when they're oftentimes a person may not be connected to treatment, or a person had been connected to treatment, but because of their own illness, they don't think they need the treatment, they don't need the medication, so they get disconnected from their treatment. And then what happens? Well, they then respond many times to that internal stimuli, to their illness itself, and causes them to act out in a way that may well prompt intervention with law enforcement or the fire department. People will call, and typically they're going to call 911, the local police department. And while we think are hopefully mindful, a lot of work is going on these days, I'm sure in your communities across the state, in terms of trying to do something so as to co-locate mental health professionals with law enforcement or fire, even have where they might be the ones who respond if there's not some sort of violent act that occurred. The reality, though, continues to be at this time, at least I know in Sacramento County, and I don't think we're unique, that a person typically is going to be taken into custody by law enforcement, if not taken to an emergency room at a local hospital, then typically they're going to end up booked in the county jail. Trina, what type of situations do you commonly see with your clients who may find themselves ending up in the county jail for some period of time and you get notice?
Yeah, there's a lot of things that will get this population noticed, typically, like you said, by law enforcement or the fire department. There can be a lot of changes in mood, a lot of changes in how they express themselves outwardly. Like you said, if they're responding to internal stimuli, I think those officers, law enforcement, fire department, and even other professionals that respond to those folks just don't have a ton of choices depending on what's going on with that individual, and have a few choices to make when it comes to, if someone's on probation, if they have a warrant, if they have other things impacting that. So you'll see a lot of that lends itself to just having a hard time in the community, and someone has called 911. And then it's up to that officer and the community partners who respond to them to understand, is this a mental health crisis or is this a legal issue? And so it's an entire everybody's learning on which is which, right? Because sometimes it's hard to tell which one is which. And if someone is having a hard time and not as agreeable and doesn't want to go to the ER and doesn't want to do certain things, we see a lot of what turns into confrontation with law enforcement or irritability or things like that then lend itself to those officers having to say, is this a safety risk or not? And a lot of times it's booked into the jail.
Thank you. And we do see that so commonly. For those of you who practice criminal law, you'll see the 148 misdemeanor resisting obstructing an officer, or Penal Code Section 6-9 as a felony, perhaps, if there was any use of force and the like. We may see criminal threats, we may see assault. But again, it's because what Trina is describing, they are not connected to their treatment at that time. It's caused them to act out in a particular way. And then all we can do as a system is using such tools now as mental health diversion or collaborative courts or what have you, is to try to acknowledge some of those equities and figure out what it is we can do. Let's go to our next slide.
Sacramento County also has the Sacramento Impact Team and the Mobile Crisis Team. Those folks have clinicians and advanced mental health knowledge in an effort to divert those situations to other avenues. And so it's expanding everybody's skills as far as how to assess those situations.
Thank you. And that's certainly an important emerging trend that needs to be, I think, robustly supported. We wanted to, now that we've kind of, set the stage, to say, okay, here are some statistics, here are some of the things that may present for us in the court system, whatever role it is that we may play. Let's now sort of say, what is it that people expect from all of us in the court system, no matter what role we play, when they come into our courts, whether they have a behavioral health issue or not, just generally, what's our day job? What are our, what are people expecting from us with their tax dollars? So the National Center for State Courts did a nice job in doing some extensive polling about this and distilled it down to these 6 categories that you see here on the screen. A person wants to have a voice, i.e., they want to be heard. Respect. They want to be treated with respect when they come into our courts, whether as a defendant, a party, a litigant, a witness, whomever. They want understanding. They want to have it where there's some level of empathy that is being projected by that court setting. And again, I think, represented in part by the figurehead role that the judge plays, I think, in setting that tone. They also want to have that setting shows neutrality. There's going to be fairness. And from that, they can trust what's happening. They're not being set up. That it's a fair, neutral place where they can be heard and they can be understood. And yes, we're going to get you guys a copy of the PowerPoint. Let's post that afterward. That's always a compliment when somebody wants it. Thank you. And they also want help. Sometimes we do a good job at that. Maybe other times not so much, depending on the court setting, but they may need assistance. So on the role of the judge, I turn to, of course, none other than, and I think we can all, have that moment of respect of Judge Rothman and the Rothman book that all the judges get. And in 2.3, he sets forth, these are the things that we're to do as judges. Require order and decorum, obviously of ourselves, of our court staff, and of the attorneys appearing in our courtroom. To be patient, dignified, and courteous to litigants. I see my DA is on today. It does not say to the district attorney, Mr. Carlson, to perform duties without bias or prejudice, to accord everyone a right to be heard, and to dispose of all matters fairly, promptly, and efficiently. So I'm going to make the following observation. Sometimes these are easier said than done. But we sign up for the job, to be sure. We know what we're getting ourselves into. But when you are in one of those large calendar courts, and the volume is significant, and the pressures are real, whether on judge, the court clerk, the court reporter, the bailiff, the court attendant, the lawyers, right, getting through these calendars. That can be challenged. It can also be challenged if you have a difficult lawyer or a difficult party to the lawsuit itself. That will start to challenge some of this staying patient and courteous, for example. And I know also, and I believe this to be true, the challenge becomes even greater when you have a person who has a serious mental illness, who may be responding to their illness there in that very court setting. Again, it's one thing when it's in one of our behavioral health or mental health treatment courts. Even then it can be stressful, but at least we're on notice. We hopefully have some training, some empathy. But I know in the large calendars like I had in our county jail for a couple of years, that a person who is being disruptive can be kind of a calendar killer. They somehow didn't get the script, the unspoken, unwritten script as to how it is someone is to conduct themselves when coming into a courtroom. This is the meat of our discussion here today. We wanted to set the table for you all. our behavioral health criminal justice services staff, what happened was that so as to help shed light, on how our court system operates, particularly outside of our specialized collaborative courts, with consumers of our court services suffering from mental illness, whether defendant, litigant, family member. So as part of the behavioral health education series, the criminal justice services staff partnered with peers over in Alameda County and conducted a remarkable series of recorded interviews with those very same people. And Michael Roosevelt was kind enough then, with the hours and hours of these recordings, had pared down for Trina and me various excerpts so that we could then try to identify what we thought to be key excerpts that would help underscore some of the discussion we're having today. And so we did that working with Michael and with Jenny Clark to say, okay, these seem to encapsulate important information. So go to the next slide. So with their permission, we now have their photographs, which I love. We didn't have those photos just last week. I don't know about you, Trina, but I felt like, wow, we really got to know them. We knew their voices, and now we see them, right?
Absolutely.
And so we have Michael, you'll see, has been in the criminal justice system himself. Barbara, her offspring, had been in the criminal justice system with serious mental illness. And then Damon, also himself in the criminal justice system. And why don't we then at this time go to, I think it's an excerpt with Michael.
But if you could talk a little bit about how the judges talked to you and what things they did well and what things they could do better.
The judges, well, for me, in my experience, they automatically kind of put me in a category, because of my charges maybe, or the color of my skin. Maybe they might have put me in this category. But my dad instilled in me, you do the crime, you do the time. So it really wasn't, I kind of feel I got some fair shakes in my sentencing, all the different times. It was maybe one time that I wasn't guilty and I didn't, and I beat it in trial, So I had pretty good experiences within the court system. Yeah, it's just like, my case went so fast. It's just like automatic, boom, sentencing, gone, instead of being like, let's see if we can get this gentleman some help. Let's see, what can we weigh out some options about, if we do this or if we do that or whatnot. It was just so bing, 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 bang, real just fast. Didn't take out no time to really look in my case personally or anything like that. It was just real fast.
So Trina, let me ask you, the bing, 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 bing went real fast. I know you've observed courts a lot over your career, not just in mental health court, but in our regular courts as well. Does what Michael has to say, does that come as any great shock to you?
No, not at all. I think for anyone who doesn't spend a lot of time in a courtroom, the quickness with which things go, I think for me initially was pretty overwhelming. I think it took me a few months to even acknowledge that I didn't even know who all the players were when I started coming. And I think, as we've established before, folks with persistent mental health challenges are already struggling with deficits in other parts of their life. So to come into this culture of a courtroom, it does kick off real fast. And Judge, you know who all the players are because you see them in and out every day. for someone who is struggling in other parts of their life to come into that space, it does go really fast. And we have people coming through mental health court that get out of jail after weeks of being explained what's coming down the pipe and are still sitting in front of me going, nope, nobody told me that. Nobody told me I was on probation. Nope, didn't hear any of that. So it just doesn't always compute. And I think speed is part of it, but also just lack of overall understanding of the culture of the courtroom.
Thank you, Trina. Let's go to the next clip if we might, Octavio.
Struggling for a word here, but some discretion and be able to do something different and really listen, because I feel like I don't feel that listened to. And I did bring letters. She read the first one. The second one was just set aside as soon as she saw the letterhead on it, and it was updated. And I have more letters too, but I don't know that they're read. I think that what people are writing about him, and that people in the community that were working closely with him, that's important. And then when we did do a pretrial hearing, and when we did that, I didn't feel like we were listened to at all. The lawyer was there, but he didn't really talk to us about what had happened that day, and then the prosecution had a whole thing, like it was like a trial. I mean, we sat there. I wasn't prepared for what was happening, and the officer who was there was like saying things that were not true, right there, and that I remembered differently, and no was correct. So that judge just seemed like it was it felt like it was just it felt like he didn't care at all, It felt like it was an academic exercise and that we weren't even sitting there. That's how it felt.
I suspect that you all can see why we chose that excerpt of Barbara, the mom of someone who was involved in the system with mental illness. I don't think any of us would want to have it described in that way, that the actions that we took or seemingly did not take looked to be we didn't care, was an academic exercise, or that things weren't even looked at. And I think it's a very important, as a reminder of, the mindfulness that, we in the court system, we're being keenly observed by those that come into our courtrooms. And sometimes it's hard to stay perfectly on message or to take the time, and a lot of letters are being provided or whatever it might be. And you have these large calendars with the stresses going on, but there is a level of almost role playing that we need to do so as to those earlier points about build trust and to show respect and to show that they've been heard when coming into our court. Trina, because this is a mom of somebody, and I happen to know in our years in the mental health treatment court, you've got a lot of very involved parents. It seems much more often, moms than dads. Does Barbara ring some bell for you?
Yeah. Moms, dads, cousins, aunts, they're really great champions for folks with mental health challenges of any severity. And they often can bring a really important lens because they're sometimes living with those individuals or in just daily contact, and can bring a lot of context to maybe what they're struggling with that day or have been struggling with. I heard her say, I wrote letters, and people that knew him wrote letters. And I think that's very common. And just a little goes a long way, the importance of acknowledging that you've received them. And Judge, I've heard you say, I can't get to that letter right this second, but I have it and I'm going to review it. And just, they speak on behalf of our folks when they're struggling the most.
Thank you. Let's go to our next slide. So this is going to be, so what is it that we can do? All right, so we've heard from folks who perhaps have had a less than favorable experience in some of our courts. I would love to say, oh, those are just one-offs, but I suspect that not to be fully true, right? So we wanted to highlight for you this 2-page judge's guide to mental illness in the courtroom. And Jenny, my understanding that was provided, is that right?
It will
It
be
will
at
be
the end.
provided after the webinar.
Thank you. And I have to say, I'd never seen this document before. And that's because it was on the judge's educational portal, Seranus, which will reflect how often I do or do not go on to Seranus. I can't even keep up with my stack of daily journals. But this 2-page document that Michael had shown us, I should say, really does a beautiful job. It was created by the National Center for State Courts and was done in conjunction with the likes of the American Psychiatric Association, who are key people behind things like the DSM. And I love a good cheat sheet. Give me a 1-page or 2-page little cheat sheet, that you've got me. That will make it into my courtroom little binder I keep. Whereas if I have big, thick materials from some program, they're going to gather dust in chambers somewhere typically. I don't think I'm alone on that. So this 2-page guide was developed to try to provide some assistance. And so we agreed when we were preparing for this, hey, this really helps frame the exact issues that we've been talking through when we were meeting and several months back when we first started discussing our goals for this program. So let's delve into it a bit. Let's go to the next slide. So the way it's set up is you'll see, they talk about contextualizing the observations, meaning, all right, what is it that we may see relative to persons suffering from mental illness coming into our courtroom to help us then understand a bit more. Appearing in court is an anxiety-provoking experience. I will confess, doing a webinar about the half hour before starting this up, I was experiencing anxiety. So Trina, is this unusual? Do you think that your clients experience anxiety when they know they have to come to court?
No, not at all. I mean, coming to court is a huge shift to their daily routine, whatever that routine looks like. And the things that they have to do to be there on time, right? Whether that's an 8:30 calendar or 9 o'clock, is definitely not a part of their regular experience. At least in Sacramento, navigating downtown may not always be an easy experience for folks. And the things they've had to do to prepare to do that. Do they have a way to get there? Did they get enough sleep? A lot of times folks with persistent mental health challenges aren't sleeping the same way you and I may be sleeping some days. Can they get up in time? And maybe they had to cancel work or do a whole bunch of other things just to show up when they showed up.
Thank you. They may not be prepared to navigate the complexities and demands of the justice system. I think that just sort of goes without saying. The one that really jumped out at me, folks, again, I've been doing this for about 9 years now, and was this one. It was my aha moment. Individuals may exhibit skills that have allowed them to survive in their communities, but may be poor fits for interacting with the court. So out in the community, being tough, perhaps even argumentative, or to withdraw and to be silent serves them well. Whereas that's not the best set of traits coming in. Trina, do you think that's an accurate description for your clients, for any of them, in terms of what they need to do just day to day?
Yeah, absolutely. It kind of all ties together, like all these sort of overlay, right, between it being anxiety provoking. A lot of folks, we don't know, Judge, you may not always know what that looked like before they show up on your calendar for that specific case. And lack of understanding or just being unfamiliar with all the players, they see a bailiff and To you and I, that's a bailiff, right? To keep order in the courtroom and to help out. To them, that's an officer who's going to arrest them. And that it just sort of all rolls together and overlays one another. And you're going to see their defenses come up a little. I mean, I've not heard a single person that I've worked with coming into their first court appearance in however long without any fears and reservations that they will be going to jail. It is almost always the decision tree their brain tells them. I'm going to go to this hearing and I'm going to get arrested. Even if that's, I mean, I've learned in working with you, Judge, more times than not, people are not getting arrested that day. But that is the story that they are believing. And the whole team in the courtroom is who plays a role in how that mitigating that fear for them.
Thank you. And so I look at these three and say, look, again, we have this sort of social compact about how people are supposed to act when they go into something like a courthouse, into a courtroom. And that it's not something that people are given a cheat sheet in life. You're just supposed to sort of know this. And when a person deviates from that unwritten script, that's when problems can come up. That's when the Rothman guide can be a challenge for the judge. That's when the bailiff or court attendant can feel particular stress because of trying to control the tempo in his or her courtroom, right? Let's go to the next slide. These are, will we know it when we see it? So how will it manifest? And I think most of these, I would think, are somewhat obvious. Their appearance, they may look older or younger than their date of birth. Their clothing may not look like what you're supposed to wear when you're coming into court. They may be in a bathrobe. They may have slippers. They may, who knows? They may be confused. They may have gaps in their memory. They may answer questions inappropriately. They may be belligerent. How dare you be belligerent to the judge, right? They may not be paying full attention even when they're up at the podium and their case is being called. Trina, I think we've seen all this behavior over time.
Yeah. Yep, headphones are pretty common too. A lot of headphones, music playing.
Why are the headphones common?
Depending on what people struggle with, music can be a really good coping skill for folks. And while it may look like it's distracting folks, it's a lot of how our folks listen and manage the day is managing anxieties. But I would say it's probably most common. I've seen it so much in court when we were in court, right? It was never surprising how many people had headphones or came with speakers playing their music.
I will confess, with my little Bose speaker in chambers, I have a song list from Spotify of like calming music that helps me with my stresses sometimes. No one comes in and tells me to turn that off. Let's go to the next slide. Also, then they may avoid eye contact. And that's not always a real good trait if the judge is talking directly to the person in court and we are trying to have a conversation, maybe a change of plea or asking questions of them. That could look disrespectful with a normal, quote unquote, a person not having any mental illness at that time. That we would expect the person to have some level of eye contact with us. Or we may find there's an abrupt change, that they've gone from docile to aggressive and just like that without us even knowing. They may speak too fast. It may be too slow. It might be long pauses in their speech, which is going to get on us if we have a large calendar and, oh my God, would they please hurry up in answering these questions or whatever it might be. They may say interesting, unusual things. They're simply disconnected from what we are observing in that very environment. Trina, have we seen these kinds of behaviors?
Yeah, so I think maybe one or two, sometimes all at one time. I mean, because we're also compounding someone's struggles that they're having every day outside and putting them in an environment that is increasingly stressful.
Stepping back from the 2-page guide, when we were talking about, well, what can we do? Right? And so what is it that we could do to run our courtrooms in a way that addresses some of these dynamics? And I suggest these are some of the things I started to do as I was doing the collaborative court work, but I was having still large felony calendars separate from my collaborative court work. And so creating an expectation or an openness of wanting to be informed of persons who might be experiencing mental illness before their case gets called. And so my attorneys, if they're regularly appearing in my court, my bailiff, they are going to know. I'd rather know ahead of time if it's at all possible. And that's where the bailiff or the court attendant, they're so critical. I mean, they are our greatest emissary for the court. They're going to be the ones who have the direct contact with those coming into our courtrooms. They're also going to be probably our best eyes and ears in terms of if someone appears to be having challenges, that they can let the court, particularly the judge, give us a heads up. And my bailiff knows, I want to know ahead of time, so I'm better prepared. So I'll be able to stay patient, courteous, dignified. I won't hopefully, cause trauma to somebody coming into my court. Clearly, defense counsel, very important. If they know that their client has an issue and maybe they're having a hard day on that day, or there's a dynamic, the family's there, and there's going to be some tensions because the family wants something to occur different than their own client does, if they can let us know ahead of time. But even if we don't know ahead of time, because that's obviously the ideal, but we become aware as it's playing out real time, of course, there's no harm then for the judge to ask counsel to approach. So we can get some information about, so what's going on with your client? This doesn't seem to be going too well. Is he or she okay, etc. Many times I'll want to know, do they have anybody in the courtroom with them? Especially family members or a social worker. Are they there? And do they care? And if they are, I will many times from the bench acknowledge that they're there and play off of them a little bit and say, Grandma, thank you for being here. Has he been behaving himself? And especially if I'm seeing that the client is, the participant is smiling. So I'm going to make you a deputy probation officer, ha, 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 whatever it might be. And kind of redirect the person and say, look, you need to keep making your grandma proud or whatever it is, so that, it reinforces they are going to play an important role when they leave your courtroom, and that you're building that trust with the family. Like, that's a really good judge that we got our case in front of. We're so fortunate that this judge cares about us, cares about our son, daughter, grandson, granddaughter, right? Also, just from calendar management, is this the best moment to hear the case? I know that can be hard. It's hard for me anyway. If I'm going along in the big calendar and all of a sudden, plunk, plunk, wait, this person's not following the unwritten script. Should we trail this matter until just before we take a break, for example, or when we got through more of the calendar? Would it be a better time for us, this morning's calendar, but a better time perhaps, at least for nothing else, do I need to take a deep breath, not get too worked up myself? Am I sensing the courtroom feels stressful? So those are just practical type of things. Let's go to our next slide. This is back to the guide. So the guide says, when you're interacting with a court participant and it's affecting their appearance in the courtroom, speak slowly, avoid jargon, be transparent, explain what's happening, treat the person with respect. Give written instructions. Nothing worse when everybody starts to say, okay, they're going to have, okay, so you're going to have to come back to court on this particular date. Between now and then, you need to go to probation the next 48 hours. And then you're going to contact your provider, and you need to, at that time, Trina, how are they processing that information?
Yeah, they're not. A lot of times it's in that same tune of they may be acknowledging, okay. And then as soon as they're out of that space and feeling a little more relaxed, not having any clue what's next. When's my next court date? Who do I need to talk to? And it's a lot of closed-ended questions in court. There's a lot of absolutes that kind of get lost.
And Trina, I know you love this last bullet point here. In fact, we put a little bit in bold to this about using principles of motivational interviewing. Aren't you guys all doing some training on that right now?
We are, yeah. In Sacramento County, motivational interviewing is on track to be an evidence-based practice. And so at least here at TCore and Hope Cooperative, doing lots of training, additional training on that. And I think a lot of those foundations can serve everybody really well in court. I think empathy, but tone of voice and how we talk to folks is really imperative. And like I said, more open-ended questions and staying curious. If you, judge, aren't understanding something or feeling a little confused about anything, it's highly likely the person on the other end of the podium is 10 times more confused or lacking understanding about what's going on.
And I'll give a shout out. I believe it's Katie Maeda from Santa Cruz will be doing a segment on motivational interviewing at the California Association of Collaborative Courts Conference coming up in a couple of weeks in Monterey. I know we just had a questioner in the chat room. Michael, could you read it for me? It was from Abernathy.
So what are your thoughts on the following? Client is in custody and appears not to understand the nature of the proceedings and/or to cooperate with counsel. If you request that the proceedings be suspended, the client will remain in custody for multiple weeks while competency is being determined. If found incompetent, they will likely sit in jail for multiple months pending transportation to the Department of State hospitals. So what are your thoughts?
This is Ron Abernathy. There's a second part to that, which is the prosecution has offered a resolution of the case that will result in the client being released immediately on some sort of probation, which is something that comes up frequently in misdemeanor cases.
And I suspect it goes right to the ethics for defense counsel as to, making that decision then as to, can you ethically go ahead if you think the client is incompetent at that time, where you should be declaring a doubt as to competency, but mindful of all the delays like you're describing that will result, particularly with the backlog of commitments to state hospital. You're getting a sweetheart deal, quote unquote, being offered at that time. And I don't know what it's like to be in defense counsel's shoes. But I do think that sometimes, and I see this in the collaborative courts, thank goodness, so many times it's about, don't have a Pyrrhic victory. What's it going to look like then if you take that sweetheart deal and that person is out right away, but they're in the condition that they're in? Do you have a game plan then for them going forward so as to have their mental health needs be met? Are they connected to a treatment provider or not? Or are they simply going to be released to the street, credit for time served, but in a mental state that otherwise would go as far as being incompetent? And so I think sometimes I find, with this throughput justice system we have, we're moving things along and, it looks like this is a good outcome in terms of the case itself, but how is it for the client? And I'm sure that's a profound challenge for defense practitioners. Let's go to the next slide. And here I wanted to really highlight for a moment one of, I think, my own best practices. Again, I hate to, because it sounds egotistical. My one thing that I have alighted on over time is this. On the right-hand column there, it says, establish a good personal connection. And then I put in there, learn something about their personal life and keep track of it if possible. What I've learned to do over time, it took me a long time, is as I would learn something about a person coming to my court who has a mental illness, but they tell me or tell us that they have a dog and they love their dog Bella, or they have 3 cats, or they love to play music, or they love to play a particular video game. I write that down. And I keep that in a tickler for future court appearances. And that was in my general felony calendar court. Now for mental health court, I asked court staff, as I learn this information, they keep track. And on my calendar, I have personal information that I can glance down. So when I have a participant, I can talk to them about those personal issues. And I have found that to be the greatest tool I've ever had for myself, connecting with this clientele, is to show them the respect that I care about who they are, not just what they did. And it's so much more fruitful to talk with them about how their dog is doing than it is about, are you on your medication? Did you go to your doctor's appointment? Are you staying away from the marijuana? It's not to say you're not to have those conversations. That doesn't bear you much fruit. And when I would go to the National Association of Drug Court conference, they say you should spend 3 minutes talking to a participant for each case. But how in the world do you do that? Then I've come to understand, oh, this is how you do it. You get to know who they are in a more personal way. So I wanted to highlight that. We have now another clip to share. If we could go ahead.
Well, the shame was admitting that I was broke. You keep telling yourself, I'm all right, but deep down, hey, it's like really being financially broke and you trying to say I'm still happy, or overweight and you're telling us I'm happy. This is me and I'm all right, but you're really unhealthy. It's having that idea about it instead of saying, no, I'm not healthy. I'm not all right being broke. I'm not all right being overweight. I just accepted it and made it. I'm gonna reverse it and say I'm okay. I'm not all right being beat up. I'm not all right to say I'm scared. How many people tell people they're scared? And that was the thing till came the time to say, well, let me let this ball and chain go. I'm scared. And it's okay to be scared, because I think I growed up with the John Wayne movies and the Army. You don't show fear. But I'm scared all the time. Till I could fear this imaginal boogeyman ain't real. And if he is, well, he don't have to live with me. I don't have to live with him.
Think about, that's all going through his mind. And doggone well, he's not sharing all of that with us when he's in court. I mean, maybe in behavioral health court, but even that's on a rare occasion. Trina, I know this really connected for you, that clip. Is that fair to say?
Yeah, for sure. Because when folks are incarcerated, we've talked about court culture and culture of mental illness, but jail culture is a whole different ballgame, and folks have to align certain directions to stay safe. And, people can be at a deficit to acknowledge that they have these challenges, which puts folks at greater risk. They either have to align with folks to keep themselves safe, or in some ways give up their acknowledgement of treating struggles that they're having with their mental health.
Let's go to our last clip.
Why you think there's sort of reluctance to talk about the diversity within people who experience mental health challenges?
Well, sometimes it's culture, other times it's ignorance. and the other time it's a self-induced ignorance. But in prison, like, okay, we had the whites and the Mexicans, and then the blacks who were broken down in different groups, southern, northern, stuff like that. Well, the Mexicans got a culture, along with the whites, you know. It's a sign of weakness. You're looking for soldiers. So, and we try to explain to them, if I was diabetic, it wouldn't be a problem with me getting my medicine for diabetes to stay well. They don't look at mental illness like that. They look at that as a sign of weakness. So you have the culture, well, if you need to go see the psych, you soft, you weak, you can't do this, then people prey on you. Or our army don't look strong. In prison, it's always a them versus us. If it's not a them versus us against staff, it's a them versus us against each ethnic group. So the blacks can't look weak to the whites. The whites can't look weak to the black. The Mexicans can't look weak to the whites. They can't look weak to the blacks, vice versa. So now we have this fallacy of what strong is when we are really scared and angry and all the other gumbo mixed up. To say, you know, no, this is a part of life. Humans suffer with mental illness, and then when you're in a man-made environment, it either compounds the issue with stress or whatever, if it's hereditary or whatever. But as we say, our homeboys, if you talking to yourself or acting erratic, you crazy or you weak. So you try to fake it, you know, till one day you kill yourself in the cell or kill somebody, you know, which we see in CDC. Or the doctors say, oh, he's faking it, or it's not that bad. Till he jumps on somebody or something, it's not that bad, you know. So that's what goes on, why a lot of people, because the Mexicans, if you go to the mental health, you got to lead a line. You can't stay in population. So you get comfortable being with your friends or some kind, but I'm having a problem now that I'm hearing voices, I'm thinking about hurting myself, I don't want to be around nobody. Well, if I go over here and see the psych, when I come out this, I got 3 days to get up off the line. So that's a weakness. So if I don't want to leave the line, I don't say nothing. And if I don't leave the line, I get attacked. So you got those little things, what goes on, you know, what stops us from saying, I need help.
Judge Brown, there was a question that came in. I think you probably saw part of it, and I want to make sure we get to it. It sort of follows the first question you answered, and that is, or when as practitioners recommend clients remain incarcerated until a safe and appropriate placement is arranged. If immediate places to release them back in, to them place them more at risk. Some public defenders state that it is a violation of the client's right.
I have no doubt that the ethical challenges that it present for defense counsel, and I respect the role you all play immensely, as I do our prosecutors, in terms of, you know, where does that line, where does it get drawn in terms of sort of the best kind of holistic interests of your client versus sort of, in this case, what normally I would do, and that, yes, he wants out right away. I know it's not going to be a good place that he's going, but otherwise we need to wait for, could be some weeks before the person gets out to something better. And, you know, I know that that calls on all of you to probably try to deploy world-class diplomacy skills in terms of having a person come to a point of acceptance, or at least not outright revolt, to say, yep, that makes sense. And whether a family member might be involved to help assist with some of that discussion, or a social worker, but I know a lot of times, nope, it's just you and your client. And I know in the collaborative court world that, you know, it's different, right? We all get to sort of push the boundaries a bit in terms of what we normally would do, because we all subscribe to this overarching objective of treatment, what's in the best interest for their treatment. But in a regular old court, I know that can be a lot different. So I guess I'll just say, I feel your pain. I wouldn't want to be in your shoes necessarily. But I'm sure you have very difficult conversations you have to have. I do want to also just react a bit to this clip we just had from Damon, because to be honest, I never really got cultural focused mental health training when I came into my assignment. And, we're all taught really to be more colorblind and to not have bias, right? And here, Damon's making it real and talking about, hey, he's just saying, hey, if you're Mexican and you say you got mental illness, you got 3 days to get yourself off the line, or you're going to get jumped, or whatever that is. That's an important discussion. This is important information. I got people coming into my courtroom, and if they, as part of their culture, are going to have extra dynamics involved in terms of the things we're talking about with them so openly. Trina, I know obviously you've seen this in your career. I think I remember one of our planning sessions, you talked about like in our Hmong community, which is fairly significant in the Central Valley, this presents.
Yeah, absolutely. And just the decisions folks have to make, there's still so much stigma across different cultures around mental health challenges in their communities. And Damon really articulated it well when it came down to the culture of the jail and their, or in prison at CDC, as far as the cultures there. But that remains existent out in the community and other places where, in some cultures, the family will take care of the unit. And there's not as much acknowledgement of the challenges because we'll fix it here. And so it really just comes down to culture across family systems, across developmental systems, across, these big systems, jails and prisons, to know that it's still an open dialogue that needs to have. I mean, Damon said in the first clip, if I had diabetes, I could go to the med clinic and I could get medication for my diabetes. But if I hear voices, I can't go do that. So there's still a lot of work to do in that regard across all these different systems and cultures to make treating your diabetes as readily available as to treat mental health challenges as readily as we can treat diabetes.
Let's go to our next, I think will become our last slide in the interest of time. We knew that this, or the next one after this, I apologize. We also knew that it would almost be, a dereliction of our responsibility not to at least acknowledge the level of trauma that also many times is involved for folks who come into our court system, and then particularly those with mental illness may well have trauma in their background. And this can be a whole, and there are training programs on this. A lot of good work is being done on a really emerging topic of trauma-informed care in our court systems. But for those of you who are passionate about that, one, thank you. Two, we wanted to certainly acknowledge that we were not mindful of it. And Trina would love to talk about this the next hour. Michael, we are essentially out of time as I see it. I know
Yes.
you would prompts for questions or any other questions that are out there that we need to address as we wrap up.
And if we can't get to the questions during this webinar, we can send the questions out to faculty and then they can answer them. We can send them out to everyone. So no worries if you don't have it now, you can write it later and we'll get it out to Trina and Judge Brown.
Great. All right. So Michael, can I just make a few closing comments? All
yes.
Right. Essentially then the closing comments would be to thank everyone. Thank all of you who had taken time out of your busy lives, gave up a lunch hour and then some for this presentation. Thank you for caring enough about the topic at hand that you would take this time. Obviously that reflects stuff you're doing in your daily lives. So thank you, thank you. Thank you to Michael Roosevelt and to Jenny Clark and to Octavio for all of your professionalism and all your hard work and assistance bringing this together. We are flattered, honored that you would look to Sacramento to help share a story. We are very aware there are many jurisdictions who have that much more expertise, who, and many of you, I'm sure, on this call, who could well speak to this, perhaps better than I, not better than Trina. But finally, to my pal Trina, Ms. Hatler, thank you for the work you do every day, the impact that you have, but also thank you for being my partner in crime in pulling off this webinar today.
No problem. Thank you, Judge.
All right, Michael, I think we're done.
Yeah, there will be an evaluation, a very brief evaluation that you'll receive post this program. You'll get the entire slide deck, and it lists some resources that are available to you, some tools, some links to things that you can actually get to. So thank you so much, and have a rest of the day, a wonderful day. Take care.